eventually the local authority could say that that mother is not protecting the children by going back into that relationship. And it's something of a controversial point that the local authority can have that attitude. So that's on the one hand, but then on the other hand, in the private family court, parents, mothers feel like they are being pushed into having to allow contact and to encourage contact with a co-parent where there has been extremely serious abuse. Hello and welcome to this episode of the Survivor Diaries. The purpose of this video is to give a very general overview of the different types of private family law applications and procedures that may be being experienced by a couple, a co-parenting couple who are coming out of or separating a marriage or a relationship, and typical orders that the court may have to make. Now, this is not an exhaustive list, and there are many different, very specific types of orders. So what I'm doing, as I'm doing in a lot of these videos, is just giving a very general overview so that you can see what kind of application is happening, what kind of proceedings are happening. And of course, as with all of these videos, especially focusing on child arrangements and when there has or has not been domestic abuse in that parenting relationship. Again, just having to disclaim, as I always do at the start of these videos, I am a solicitor in England and Wales, and therefore the law that I am making very general suggestions about how they work. It is very general because as a solicitor I cannot give specific advice without knowing all of the information about the case. So these are just general videos to help in particular litigants in person or people who have to represent themselves in the family court without a solicitor. First of all, if a relationship is separating, if it is a marriage, then one of the more obvious sets of proceedings that may be happening are divorce proceedings. And the divorce process itself is a very straightforward process. The parties may not even need to attend the court. And in these videos later on, we will go through the divorce petition and the different, there's only one ground for divorce, which is the irretrievable breakdown of marriage, and that is established by one of 5 facts. As I said, we will do a whole episode on that. But anything to do with the divorce, what you'll see in the paperwork coming from the court is that the case number distinguishes what kind of application is happening. So to give an example, I'm going to pick some courts in Yorkshire. The court in Bradford is where all divorce petitions would be sent to. So those cases would come out with a case number which will start with BD being the case, the county court where it is, or the family court where it is, 19, which is the current year, and then it would have a D, so it's divorce law. And that is going to be all of the different steps of the divorce itself, which is a very relatively straightforward thing to do. And alongside this, you can have additional proceedings going along at the same time as divorce, sometimes called ancillary proceedings, and this is how the assets and the finances are being separated upon the dissolution of the marriage. Those financial proceedings often go hand in hand with the divorce, and the divorce may even be staggered or paused occasionally so that it ties in, so that the final stage of divorce, decree absolute, happens at the same time as either a financial order, a final financial order, or an order of agreed finances and a consent order about the finances going forward as separated parties. There are 2 examples of where you could be having a case number, for example BD if it's Bradford, OX if it's Oxford, YO if it's York, and then 19 being this year, or 17 if you get the gist, I'm sure, and then D for divorce. That will identify the case number in England and Wales. Another set of proceedings that could be happening, especially in situations where domestic abuse has been a feature between the parents, are the protective orders, which come into play from the Family Law Act of 1996. The Family Law Act is the one that can make orders such as a non-molestation order and an occupation order, and these are both civil orders made by the family court, and in the first case the non-molestation order will prevent a person from acting in a certain way to somebody that they are related to or associated with. I'll come back to that in a minute. The non-molestation order in itself is a very protective civil family order, because if any of the conditions of the order, and it may be must not use violence, but it may also be must not come within 100 metres of this property, if they are breached, it's automatically a criminal offence. So breach of a non-molestation order is a criminal offence. And when a person obtains a non-molestation order, and we are going to have a full episode about that, when they obtain the non-molestation order, that order is then served on the respondent, the person who the order is about, and it's also served on the local police. And the local police force will then have this, so that if a 999 call is made relating to the parties in that order, then their response is going to be particularly fast, and there will be potentially an arrest for a breach of an order, even if that is something that could be quite in itself quite small, or to the outside world maybe not much to look at. So for example, if an order said, a non-molestation order said, must not communicate with the applicant for the non-molestation order, save for the purposes of arranging contact, if then the respondent to that non-molestation order then went, okay, well I'm going to send a birthday card anyway, nothing to do with contact, and could even be argued to have been an olive branch, a friendly gesture. But what I'm hoping you can see is that it's actually a breach of the order, and therefore it's a criminal offence, because the order had the terms that there was to be no communication save for the purpose of arranging contact. And it might seem to the outside observer that that is a little bit harsh. However, speaking from the perspective of somebody who has experienced domestic abuse and the subtle ways that it can affect and the hold that it can have over people, that can be incredibly menacing to a person if they are subjectively in that situation, in that abuse situation, or just out of that abuse situation. That's the non-molestation order. In addition to the non-molestation order, made sometimes at the same time on the same application, which is application form FL401, an occupation order can decide who is going to remain in the party's home following separation. That's again something that we're going to cover in another episode. It'll be a part 1 about the non-molestation order, part 2 about the occupation order, both of these being made on the same form to the court. Both of these are free applications to make, and the reason that they're free is so that people can get access and help, immediate help if necessary, with protective orders in family law. These are governed by the Family Law Act of 1996, as I've mentioned. And so in the case number, for example, if it was Harrogate Family Court, you would see HG for Harrogate 19 and then F, which means it's a Family Law Act order. And that would be a non-molestation order or an occupation order. Another order that may be made under the Family Law Act would be the Forced Marriage Protection Order. This is something, again, we're amending legislation, so we're amending the Family Law Act of 1996 and inserting a section as society's attitudes about domestic abuse change and move forward and progress. Different things are being inserted into the older legislation so that the law can play catch up to a certain extent with what needs to happen in society. So forced marriage protection orders can also be arranged very, very quickly, just like the non-molestation order, the occupation order. And a final order would be the female genital mutilation protection, and that is from the Female Genital Mutilation Act of 2003, and that was amended by the Serious Crimes Act of 2015, again meaning that emergency protection could be put in place. Another thing about that is that it also linked in to private children law proceedings, and it inserted a section, I believe it's section 5A, into the Children Act, which also meant that the court could then make a Section 8 order, and I'm going to come on to that in a second, in respect of the child or children involved in that case. So some protective orders, the expected orders and procedure that you might see on a divorce, on a separation, either or, you may need these protective orders. We're going to come on to private children law last. Now, children law is all governed by a piece of legislation called the Children Act 1989. And it sets out into two sections, and you'll have solicitors practising and specialising predominantly in public law, and other solicitors specialising and practising predominantly in private law. Public law is where the local authority has different powers given to it by the Children Act, so that they can, for example, make an emergency protection order, which is a very short order, a matter of days, which allows the local authority to remove a child and take that child into care if there is a serious risk or a significant risk of harm, is how it's termed. They can also make child assessment orders, they can make supervision orders where the parental responsibility is being shared with the parents, and they can also make care orders, which is where the local authority can take over the parental responsibility of the parents. And that is in cases where, unfortunately, both parents have their own difficult issues to deal with. They may be young, I'm not going to fall into stereotypes or anything like that, but there will be issues and reasons why the local authority has felt that it needs to step in. One of the interesting things that I see concerns a lot of people is the fact that the local authority will see domestic abuse as a concern, and if they are aware that there is an abusive relationship, and for example that the mother, and again I'm going in my gender specific, the mother keeps going back, the children keep witnessing domestic abuse, the police are called, it keeps getting referred, eventually the local authority could say that that mother is not protecting the children by going back into that relationship. And it's something of a controversial point that the local authority can have that attitude. So that's on the one hand, but then on the other hand, in the private family court, parents, mothers feel like they are being pushed into having to allow contact and to encourage contact with a co-parent where there has been extremely serious abuse. And you can possibly see there's a little bit of an irony here. Either the local authority is saying domestic abuse is a big no-no, or the family courts need to be looking at this and saying, well, if it was children's services looking at this behaviour, and if he was shouting, taking drugs, again being gender specific, following these patterns that are there in the classical patriarchal system, and how domestic abuse mainly presents itself in the work that I do. This is leading into the group of orders that I have the most involvement with. So this is private children law, and it's in part 2 of the Children Act of 1989. And this section of the Children Act has a section in it, Section 8 of Part 2 of the Children Act. Now, Section 8 is all of the orders that the court can make in respect of the children, and as I keep saying, this is not an exhaustive list, but these are the Section 8 orders, these 4 orders that I'm going to mention now. So there is a living with order, there is a spend time with order, and there is a specific issue order, and there is a prohibited steps order. And if you look at Section 8 of the Children Act, you'll see that these are the 4 orders that the court is likely to make in a typical Section 8 application. And if you have looked at the other videos where I've got the child arrangements procedure with and without abuse, this is following an application originally made on C100, can be made on C79 for enforcement, C100, and you'll see that it's an application for a Section 8 order, or child arrangements order, or other Section 8. So what are all of those things? Firstly, the Section 8 orders have been modified. It was the Children and Families Act of 2014, I believe, which changed the terms residence and contact, which is what it was previously known as. So one parent would have residence, and the children would have contact with the other parent. So you had a resident parent and a non-resident parent. This is now changed, and it's far more able to take on board the fact that either parent, regardless of gender, can be just as involved in the upbringing of the children. And that's quite right. In a non-abusive situation, it shouldn't matter whether the children are staying at home with the father or with the mother. It's a personal choice of that family. It's now much more easy to call it a living with order. The child can be living with both of the parents in a shared care arrangement. So they can be, again, I keep referring back to the perfect co-parenting. So Paul, the co-producer of this video channel, he has the perfect, in my mind, co-parenting relationship. It's a 50-50 share, good communication between the parents, all of those good things that you need. There's not even an order in place. There doesn't need to be one, because parents, non-abusive parents, can agree the arrangements for themselves in the majority of times. So the Children Act proceedings, private children law, these, if you look at your case number, you'll know that it's this kind of proceeding. If it says, let's suppose it's Oxford, it will say OX 19 and then P. And then after that, 00515, I'm making these numbers up. Any actual referral to actual case numbers is completely coincidental. So you can see you've got your case number, which is the number of applications that the court's likely to have had to deal with child arrangements, to deal with divorce, to deal with the Family Law Act, protective orders. So I've covered 3 different types of case number there. So looking at the case number, you can instantly see what the type of proceedings are. We've had the divorce and finance proceedings. So if it was York, it would be YO19D. And then we've got the Family Law Act applications. So that might be York again, YO19F. And then you've got the child arrangements applications in private children law. Nothing to do with the local authority at this stage, although the local authority may have been involved. It's not where they are making care or supervision orders or orders that affect the parental responsibility. Children's services may be involved in private children law just in a supportive role, and the general advice is to work with children's services and accept the recommendations or advice from the individual's social workers. However, again, I'm going to say nothing can beat taking specific legal advice about your own situation. And I'm not just saying that because I want people to pay solicitors. Many solicitors that I know will give a free initial consultation to point people in the right direction, as indeed we would at my firm. So Section 8 orders, back to that. We've got the old residence and contact, that's going out. There has never been a term of residency, which is a mistake that people often make, and there is no such thing in English and Wales law as custody. So we're not having a custody battle, that's a very American term. Living with, spending time with, they are the 2 types of child arrangements order that would be made under Section 8 of the Children Act. The other 2 orders that could be made by the court, I've referred to these briefly. A specific issue order is an order that would determine a question about a child's education or upbringing where the co-parents can't agree. Typical examples might be whether or not the child can go on holiday to a certain location, which school a child should attend. They can be about religion, they can be about medical treatments. These are specific issue orders, also under Section 8 of the Children Act. Finally, in Section 8 of the Children Act, you have the Prohibited Steps Order. The Prohibited Steps Order can stop a person with parental responsibility, usually a parent, from carrying out something that they can ordinarily do. So both parents can attend a nursery and remove a child from the nursery if they have parental responsibility or PR. A Prohibited Steps Order could prevent one of the parents from being able to do that and exercise their normal function. It could also be to prevent the removal of the child from the jurisdiction. So these are Prohibited Steps Orders, stopping a person with parental responsibility from doing something that they ordinarily could do. There's the 4 different types of Section 8 orders. The last thing I want to quickly tell you about the Section 8 orders that does catch a lot of people out. So I do need to make this point because it takes a lot of people by surprise. One of the things that the family court can do when they are considering Section 8 orders, if asked a question about any of the Section 8 orders, lives with, spends time with, specific issue, prohibited steps, the court may make any of the other 8 orders at all. So what they may do in a specific issue order application is decide to look at the child arrangements again. Of its own motion, it may decide that it's going to look at how often the child is spending time with each parent, whether that needs to be varied. And that is something that people don't realise. They make an application, for example, to change a child's surname, and before they know it, the court could be asked to make any of the other Section 8 orders by the parties on Form C2, or they may of their own motion decide that they're going to look at how the child is living or what the child is doing or which school it goes to. They have that power to make any of the other Section 8 orders as well. I will just finish with another principle that the court has, and this is in Section 1 of the Children Act, and it's the principle of no order. Now, the no order principle means that if the court considers that the making of no order would be better for the child or children than the making of an order, then it must make no order at all. So it should only get involved if it's going to be beneficial and if it's going to help the child in some way. Okay, so I'm hoping that that's clear. They're the child arrangements orders, the specific issue orders, and the prohibited steps order. They're all the private children law orders that could be made and requested from the court, and I'm giving this as part of the overview in the typical types of family application that I may see coming through as I work with domestic abuse coming through the child arrangements. So if you've just received a load of paperwork and you're not quite sure what kind of proceedings are going on, this may be a video that helps you just to identify first of all what kind of proceedings you've got on from your case number, and to give you a very brief outline of what those proceedings are going to be about. We are covering all of this, some of it in very brief details such as marriage, divorce and the ancillary finance, because the main focus of these videos right the way through is going to be the child arrangements and how domestic abuse continues through the child arrangements. But needless to say, domestic abuse would have an effect on a couple who are parting, and it would affect the parties' positions in any decision making. For example, if there had been domestic abuse, the party who has been subject to the abuse may just want to get out of the marriage and not actually take whatever he or she may be entitled to, just because they wish to just escape the abuse. So domestic abuse can affect all of the different proceedings, and I hope that this has been helpful just to give you an idea of private children law proceedings. That's where we are with that. This is the public law, the local authority, which is not something that I specialise in. It's something you can quite often get legal aid for as well, if it is in the supervision, adoption, local authority involvement at that level. That may attract legal aid funding. We've covered the protective orders from the Family Law Act and also the Female Genital Mutilation Act of 2003, and I've gone into a bit more detail about the Section 8 orders that you would expect could be ordered in child arrangements proceedings. I hope that that's been helpful, and I look forward to speaking to you again in the next episode. Thank you very much for watching, and goodbye.